Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Roberto Bornhausen. I'm a member of the local organizing team from University of São Paulo, and this is the fourth panel of the second day of our event. I would like first to present our sponsors. Jus Brasil is currently the #1 law and government website worldwide that makes high-value legal information easy and quick to access. And also our platinum sponsor, Albert Einstein Israeli Hospital, is one of the best-known health unities in Brazil and Latin America. Finally, for this panel, I would like to present our silver sponsor, Urbano Vitalino Lawyers from Recife, Brazil. Now, directly from India, I would like to present Mrs. Paheli Bhattacharya with the replay of her paper, Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. This paper was presented this morning and now will be replayed for you, and Mrs. Paheli will be available here for questions and answers that she will give to previously registered questions in our platform OpenFi and also on YouTube channels. So now, please, the floor to Mrs. Paheli again for her replay.
Charya from the Department of Computer Science and Engineering at IIT Kharagpur, India. I will be presenting our work, Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. So case documents are inherently very lengthy, free-flowing, unstructured, and dense legal text. Reading and understanding these documents is difficult even for legal experts. Therefore, it is necessary to summarize these case documents. Existing legal IR systems employ attorneys or paralegals to manually write summaries. This incurs a high subscription cost of these systems. This calls for the need of developing automatic summarization systems with the overall objective to improve the legal understanding with lesser dependence upon experts. Now, document summarization is not a new problem. There are methods for news document summarization, scientific article summarization, and so on. Let us see what is different in legal case documents. So on the left, there is a news document. So as we see that it is a very short document, and the first paragraph usually summarizes these news documents. Next, there is a snippet of a scientific document, particularly a research article. So these documents are lengthy, but they are segmented into sections and subsections with paragraph headings. On the right, you can see a case document from the Supreme Court of India. These documents are lengthy, and it is just a free-flowing text with no section headings. There is something called rhetorical segments in a legal case document, but these segments are often not explicitly mentioned. Let us understand what these rhetorical segments are. So rhetorical segments or labels in a case document are the semantic functions which sentences in a case document plays. So these are usually one of the following labels. Facts, that is the sentences that denote the chronology of events that led to filing the case. There are sentences that denote the legal issues being discussed, so we call them as issue. There are also sentences that denote the ruling or judgments given at the lower courts, so we call them ruling by lower court. Similarly, there are arguments by the contending parties, which we call as argument. Sentences that have citations to established laws by the current case, which we call as the label statute. There are also citations to prior cases, and we call these sentences as precedent. There are sentences that describe the rationale or the reasoning of the court for the final ruling, and we call them as ratio of the decision. And finally, the sentences that give the final judgment or the conclusion of the court. So on the right, this is an illustrative example of how a case document, when the sentences are labeled with each of these rhetorical labels, looks like. So the first approximately four sentences have been labeled as facts. Then some sentences have been labeled as issue. Then one sentence has been labeled as ruling by lower court, and so on. So legal experts have some guidelines on how to summarize a case document. Some of these guidelines from USA and UK are given in the links below. We also discussed with law experts from India, and all of them basically devise the following set of guidelines. So the first one is that each rhetorical segment should be summarized well and have representation in the final summary. This is because often law practitioners or academicians or others wish to read only the summary of particular segments. Example, summary of only the facts or summary of only the ratio. So this following this guideline is important. Second is that each of these segments should also, the important parts of each segment should be present in the summary. For example, from the statute segment, sentences that cite the relevant acts or laws should be present. Now let us see what are the existing methods for case document summarization. So in this work, we are considering extractive text summarization algorithms. So they can be broadly classified into two main families, domain independent and legal domain specific. And under each of these families, there are supervised and unsupervised methods. So under domain independent supervised methods, we have the state-of-the-art deep learning models like SummaRunner, DELSumm, and so on. So as these are deep learning models, they require huge amounts of training data, which is expensive to obtain in the legal domain. Also, these methods were developed and evaluated on news documents, which are short. But when we apply them to summarize lengthy case documents, these algorithms become very resource intensive. Coming to unsupervised domain independent methods, so they can actually summarize any document. So they do not incorporate any legal domain specific knowledge. Now coming to the second family of methods, legal domain specific. The first one is the GIST method, which is supervised. As it is a supervised method, it requires large amounts of training data. Also, although it is legal domain specific, but there were no domain specific attributes such as rhetorical labels considered in this algorithm. Finally, there are many legal domain specific unsupervised methods. So case summarizer is one, but this algorithm does not assume the presence of any rhetorical role. So they rank sentences based on some importance score, but this score is based on a heuristic where there is no parameter from the rhetorical role perspective. The other three methods, DELSumm, KMM, and MMR, uses a rhetorical information, but just to display the summary in a templatic format. It does not use rhetorical information in estimating the importance of sentences for generating the summary. For instance, DELSumm uses TF-IDF to measure the importance of the sentences. In short, there are two main drawbacks of the prior works. The first one is that the existing algorithms do not incorporate legal domain specific knowledge systematically. While the supervised methods are expected to learn these rules automatically, there are two disadvantages. First is that there is a scarcity of expert written summaries in large amounts to be used as training data. Secondly, summary requirement may vary for different stakeholders. For example, a journalist who is briefing a case wants a different type of a summary. Maybe he or she wants the ratio to be summarized well, whereas a law practitioner may want the facts and arguments to be summarized well. So it is not practical to gather huge amounts of training data to cater to each type of the stakeholders. So in this work, we propose DELSumm, which is an unsupervised domain adaptive extractive legal summarization algorithm. DELSumm works in an optimization framework to incorporate legal domain knowledge into an objective function with constraints, and this objective function is maximized using integer linear programming. So DELSumm takes as input a document where each sentence is labeled with a rhetorical role and the desired length of the summary in number of words. Let us call that L. So given these two inputs, DELSumm produces a summary of at most L words. So the optimization framework of DELSumm has two main components. The first is the informativeness of a sentence. It measures the amount of important information contained in a sentence. We assume that domain experts will define how to estimate the informativeness of a sentence. The second one is the content words. That is the words that signify domain-specific vocabulary. With each content word is a score which shows how important that content word is. Again, we assume that domain experts will define what the content words are and how the scores are defined. DELSumm produces a summary that maximizes the following objective function. That is, it tries to maximize the inclusion of informative sentences and the number of important content words, subject to constraints that the summary length should not exceed L words. And there are other constraints, so please refer to our paper for more details on this. Now let us see how the legal expert guidelines can be incorporated into DELSumm. In this work, we considered summarizing Indian Supreme Court case documents, and our experts are the senior law students and a professor from the Rajiv Gandhi School of Intellectual Property Law, which is a reputed law school in India. So the first guideline they gave us is that in general, the summary should contain representations from all segments of a case document. And the relative importance of segments in the summary should be as follows. So first and foremost are the final judgment and the issue. Next comes the facts. Then the statutes, precedents, and ratio are of approximately same weightage. And then comes arguments, and the other label, ruling by lower court, is not so important to be included in the summary and may as well be discarded. So we formalize this in DELSumm as follows. So we have a variable called weight K, which defines the weights of each of these segments, and we assign the highest weight to the segment's final judgment and issue. And for the other segments, the weights decrease exponentially or linearly. We may as well assign discrete scores to or discrete weights to each of these segments. The second guideline is that the segment's final judgment and issue are exceptionally important in the summary. The segments are usually very short, and so they should be included completely in the summary. And to ensure a balanced representation, a minimum of 2 sentences from the other segments should be included. We formalize this guideline in DELSumm as follows. We have a variable NOS, or number of sentences for a segment K, defined as follows, that if the segment is final judgment or issue, then all of the sentences should be taken. Otherwise, a minimum of 2 sentences should be taken. The third guideline is that the important sentences should be decided based on which segment that sentence belongs to, and also other factors. If the sentence is from fact, then we will take the weight of the segment fact and also the inverse of the position of the sentence. If the sentences are from the segment statute, then we will see if the sentence contains citations to an act. So for that, we keep an indicator variable AI for statute, and this AI is 1 if there is a citation to an act, otherwise 0. Similarly, for precedents, we see if the sentences contain citations to prior cases. And for the segment ratio, the guideline is that the sentences appearing at the end of the document and those that discuss relevant statutes and precedents are important. So to formalize this, we assign the weight of the segment ratio, that is weight K, the position of the sentence, and whether there is a mention of statute or a precedent. The final guideline is that the summary must contain sentences that give important details of the case, including acts and sections of acts that were referred, names of people and places, and also sentences containing specific legal keywords are important. So we formalize this by having 3 types of content words. The first one is the acts or sections of acts, to which we assign a score of 5. The second type of content words are the keywords from a legal dictionary, to which we assign a score of 3. And then we have the noun phrases, to which we assign a score of 1. Now, let us see the dataset and experimental details of this paper. So in this work, we considered 50 Indian Supreme Court case documents, where each sentence of a document was labeled with one of the 8 rhetorical segments. So this dataset is available from our prior work. Each of these 50 documents had gold standard summaries written by 2 senior law students from the Rajiv Gandhi School of Law. They wrote segment-wise summaries and they combined ratio and precedent into one segment analysis. The summary lengths were approximately 30% of the original document, and we had 2 sets of summaries. The metrics, the evaluation metrics we considered are the rule scores between the gold standard summaries and the algorithmic summaries. We considered several baselines. So from the 4 families, which I described in one of my earlier slides. So from the unsupervised family, we have domain independent as well as legal domain specific methods. And from supervised also, we have domain independent and domain specific methods. So the supervised methods were trained on 7,100 document summary pairs. So details of this training mechanism can be found in our paper. So now let's see the results of the approaches and also some analysis. So this table shows the Rouge 2 and Rouge L recall and F scores. So out of all the domain specific methods, both supervised and unsupervised, we see that DELSumm performs the best for all the measures. While comparing with supervised domain independent methods, we see that DELSumm outperforms both SummaRunner and BERTSUM. The difference with SummaRunner in Rouge 2 is not statistically significant. Note that DELSumm is unsupervised, whereas SummaRunner and BERTSUM were trained on 7,100 documents. Next, we do a segment-wise performance evaluation. So in this table are the segment-wise Rouge L F scores of all the methods. The values in red underlined are the ones which are less than 0.3, and the best value for each segment is in green bold. So as one can observe that DELSumm performs best in 3 out of the 6 segments, and overall it achieves a balanced representation of all the segments in the summary. Especially DELSumm performs better for final judgment and issue, which are the most important segments in the summary. These are also the shortest segments. Other algorithms with no domain knowledge completely misses these segments. So we have more analysis and intuitions in the paper. So till now, we have been using expert assigned rhetorical role labels for summarization. But in a practical scenario, it is not possible that sentences in the input case documents will be labeled by the experts. So in this experiment, we use a state-of-the-art model to first rhetorically label the documents and then feed them to DELSumm. So the results show that the performance does not drop much, even when the rhetorical labels are around 80% accurate. Let us now give a brief note on the generalizability of DELSumm. So DELSumm is generalizable to documents from different jurisdictions as well as different stakeholders like law practitioners, students, etc. So this is because DELSumm is quite customizable, and this is through the different parameters like the segments and weights of the segments can be defined by whoever is using this algorithm. Also, the minimum number of sentences from each segment can be given as input. Finally, the content words and what will be the weight of these content words can be decided by the different stakeholders. DELSumm can be modified to include various guidelines. For example, if a stakeholder or jurisdiction wants the summary to have facts and final judgment, then WK and NOSK should be kept higher for K is equal to facts and final judgment. Similarly, if there is a use case that the statute sentences should be more than the sentences with noun phrases, then the score of the statute words can be kept higher than the score of the noun phrases. So to conclude, in this work, we propose DELSumm that can efficiently encode domain knowledge for extractive summarization of legal case documents. We show that it is necessary because important segments like final judgment and issue gets missed in otherwise unguided algorithms. DELSumm achieves a balanced representation and it can also handle redundancy efficiently. It is also generalizable to different jurisdiction and stakeholders. So as a future work, we plan to explore how these otherwise hand-tuned parameters of DELSumm can be automatically derived, how the weights can be automatically derived. So our implementation of DELSumm is publicly available. So I would like to conclude by acknowledging the law experts from the Rajiv Gandhi School of Intellectual Property Law, India, TCS for their fellowship, the Mirror EU project, and Complex Networks Research Group, IIT Kharagpur. Thank you, and I can take questions now.
Mrs. Paheli Bhattacharya, thank you again for your presentation. Now, our team has selected 2 questions from the audience. The first one from Brazil is a comment made by Mrs. Kaliani Pimentel. She says that you have a very interesting study and that in Brazil, this could complement case law headnotes, which are made without AI resources and generally by law clerks. Please, Ms. Paheli, the floor is yours.
Yeah. To answer this question, what you call as head notes, we call it as summary, case summary. So they basically mean the same. So yes, our method can be used along with legal experts. So in a way that the guidelines on how a head note should be produced. So these guidelines will actually come from the legal experts or the law clerks. So, yeah.
Okay, thank you, Ms. Paheli. I guess we are having some connection troubles, but can you listen to me?
Yeah, I can hear you. Is my voice breaking? Or?
Okay, no, it's just okay. The problem is the camera. I believe we cannot see you right now because of connection,
okay.
but we can listen to you perfectly. Okay, now we can see again. Okay, perfect. May I pose you the second question? Is that okay for you?
Yeah.
Okay. So 1 second. We have a second question from Mr. Carlos Braga from Brazil as well. So he says, since the automatic summarization model was developed based on the structure of Indian court decisions, what are the main challenges in adapting this model for application in other countries?
Okay, so to adapt it to other jurisdictions, we have to customize the different parameters of DELSumm. So the main parameters are like what are the rhetorical segments. So for Indian court decisions, like we have devised 8 rhetorical labels. So for some other jurisdictions, some other set of labels can be devised, and according to that, one can incorporate that into DELSumm. Apart from that, we also have to say that how much representation is required from each of the rhetorical segments into the summary. So for instance, in Indian court decisions, we understand from our legal experts that the final judgment and issue are very important, whereas the arguments and ruling by the lower court are not very much important in the summary. So we assign the weights of the segments accordingly. So this also has to be adjusted according to the jurisdiction. And finally, how to define important sentence, that is deciding like which sentences should go into the summary. So this importance score should also be defined. So here we have done it through content words. So one can devise different content words for different jurisdictions according to like what is required. Yeah.
Okay, perfect. Thank you, Ms. Paheli. We have a third question from the audience. I don't know if you are able to answer or not. Just in case,
Yeah.
I believe, yeah, I
Okay.
believe we're running out of time actually. So I'll just pass the floor again to you for a final moment, one last minute, then you can have 1 minute more. Okay.
Okay, so yeah, I can see one question that how to identify the rules to offer an effective summarization. So yeah, so these rules can either be we can either get them from the law experts or the different stakeholders who wants to have the summarization, or in the absence of the some expert, you may see some summaries by yourself, and you can have an idea that yes, from this jurisdiction this kind of summary is required, and you can adjust the parameters of DELSumm accordingly. The other question I see is that why not output just a structured representation of the case? So, so this problem is actually of summarization. So, for example, given n sentences of a case document, we have to select some L sentences out of n. So this is why it becomes an objective function with constraints, where we have to maximize selecting the L sentences which are actually of very importance. So that is the basic task of summarization. Okay, so yeah, so thank you for giving me this opportunity to present at ICAIL. It was very good to interact with the audience. So I would request all of you to please go through our paper, and we also have our code available on GitHub. So you can get back to us, to all the authors, if you have more questions. Thank you.
Thank you very much, Ms. Paheli, for your brilliant presentation. And now I have a pleasure to call here to the stage Mr. Guilherme Moraes Rosa, also from Brazil, our Brazilian colleague, which will have a 10-minute presentation of a live paper called To Turn or Not to Turn, to tune or not to tune, zero-shot models for legal case entailment. So, Mr. Guilherme, can you hear me?
Yes, I'm hearing you. I'm going to share my screen.
Okay, perfect. I'm not seeing your video, but anyways, I believe it might be my connection.
Now you can see me?
Oh, yeah, now I can see your video. Perfect. And now, please, you can share your screen.
Okay. Is everything okay? Can you see my screen?
Yes, we can. Perfect.
Okay. So first, hi, good afternoon for everybody. My name is Guilherme Moraes, and for me, it's an honor to participate in this event. And in my presentation, I'm going to talk about domain adaptation and zero-shot models. Specifically, I'm going to talk about domain adaptation to the legal domain, and also about a proposed zero-shot approach to the task of legal case entailment. Legal case entailment is the second task of the COLI competition in which we got the first place. But before starting my presentation, I'd like to introduce the other authors who participated in this work, which are Juan Chaves, Roberto Lotufo, and Rodrigo Nogueira. So, well, I'm going to start my presentation by talking about zero-shot learning and also about some related works that have applied zero-shot models to domain-specific tasks. Then I will briefly present some topics to provide a background on our work. Next, I'm also going to explain the zero-shot model that we use and how it was adapted for the COLI task. And to finish, I will present the results and the main conclusions. So let's start. Well, recent evidence shows that models trained on large and diverse data sets can achieve good performance in many out-of-domain tasks, and we can consider this situation as a zero-shot scenario, since the models were never trained on data coming from the target domain. In addition, we also know that zero-shot and few-shot models are becoming more and more competitive with fine-tuned models. So to test this new evidence and also to investigate the zero-shot ability in the legal domain, we participate in the legal case entailment task of colleague competition, and we were able to achieve great results using models with no adaptation to the legal domain. But I have to say that we were not the first to try this kind of approach. For example, using the same model used in this paper, Nogueira et al. Demonstrated a zero-shot approach that performed better than trained models on the test set of track robust. Another good example is Zhang et al. He used a zero-shot model to create a search engine to information about COVID-19, and his model was able to get a good performance on the track COVID dataset without being trained with any data about COVID-19. And there is also the work of PROLEG et al. He applied a zero-shot approach to achieve the best or second best performance in specialized tasks of the text retrieval conference, for example, the track precision medicine and track COVID tasks. Well, a common feature of all these works that I've been talking is that the models were only trained on a general domain data set, and they didn't need any domain data to achieve the good results. But despite all these works in different domains that we have in literature, as far as we know, there is no strong evidence that zero-shot models have this similar behavior on legal domain tasks. So, until now. So, the main contribution of this work is that we show for the first time for the task of legal case entailment a zero-shot model that performs better than models adapted to the legal domain. But before going into detail about the proposed approach to this task, I'm going to explain some important topics to provide a background about the presentation. Well, the first topic I'd like to talk is zero-shot domain adaptation. Zero-shot domain adaptation is when a model is able to solve a task in a target domain without receiving any trained examples in that same specific domain. In our case, the model has never seen text from legal domain, and it was only trained on text coming from general domain. Now, speaking about the COLI competition. COLI is an annual competition promoted by the University of Alberta, and the goal is to improve automated systems on legal tasks. And among the 5 tasks of this year competition, we participate in 2 of them, the legal case entailment task and the legal case retrieval task. And in this presentation, I will talk specifically about the approach we propose to the task of legal case entailment. The goal of this task is to identify a set of paragraphs from existing legal cases that are relevant to a new case. And as you can see in the table, our submissions got the 3 top scores, achieving more than 6 points above the second best team. Also, in our experiments, we use 2 models that are the Beta and Mono-T5. The Beta is an improvement over some previous transformer architectures like BERT and RoBeta, and this model is the state-of-the-art in many NLP tasks. The second model we use in this work is Mono-T5. Mono-T5 is a model adapted to the task of text rank, and it is based on the T5 architecture. Mono-T5 is also state-of-the-art in some information retrieval tasks, and it is the model responsible for the zero-shot approach we use in this work. And on the next slide, I'm going to explain how Mono-T5 was trained on a general domain dataset and apply it to the COLI competition task. Well, as I said, Mono-T5 is an adaptation of the T5 model for the task of text rank. The model was proposed by Nogueira et al. In the year of 2020, and the model was trained on MS Marco dataset. That it is a big dataset with 500,000 of text passage, and it was built for the tasks of text rank and question answering. Well, during the fine-tune step, Monty5 is trained to generate the tokens true or false, depending on the relevance between a document and a query. And to train this model, we use this input template that I show in this image on the left in green, where the letter Q represents the query, and C is the candidate document that may or may not be relevant for a specific query. On inference, the model estimates a score to quantify the relevance of a document to a query, and this score is given by the probability assigned by the model to the token true. Well, in this slide, I present the results of the experiments. All models were trained and evaluated using the COLI competition dataset, except for Monty5 Zero Shot that was trained only on MS Marco. And the approach we use for this task is considered zero shot because the model was trained and evaluated on datasets coming from different domains. In this case, we trained it in a general domain text using the MS Marco dataset. So our zero shot model has never seen text from the legal domain during training, only during inference. And as can be seen in this table that I show, the results shows the efficiency of the zero shot approach, because despite not having been trained in any data coming from the legal domain data, Monty5 Zero Shot achieves a better performance than the beta and Monty5 models that were trained on the COLI dataset. In addition, our zero shot model achieves the best result of a single model in this task, and also performed very close to the beta T5. The beta T5 is an ensemble between the beta and Monty5 models, a combination of both models, both trained on COLI dataset and considered the best submission for this task in the competition. Well, it is important to note that despite the beta 5 performance being the best among all submissions in this competition, this ensemble demands training time, computational resource, and also data augmentation to perform well in the legal case entailment task. While Monty5 Zero Shot doesn't need any adaptation. The model is already available online, and it is ready to be used. Now, coming to the conclusion of the presentation, I'd like to say that in this work, we show for the first time for the legal case entailment task that models without fine-tuning to the target task can perform better than models trained to the task itself. The results show in the legal domain counterintuitive findings similar to other domains that, given limited label data, models with no adaptation to the target task may be more robust to change in data distribution. They also may have a strong generalization ability, and they also tend to perform better on held out data sets than models trained on the target domain. We also know that domain-specific models and adjustments made during the fine-tune process are promising directions for future research, but we believe that zero-shot approaches are very important because they allow the development of high-performance systems for tasks or for domains that have low availability of data. And a good example of the scenario of low availability is the legal domain. And in addition, the zero-shot models can also be used as strong baselines in our experiments. Now, to conclude, it is important to say that this research may have implications for new experiments beyond the scope of the legal case entailment task. And it is also possible that other legal tasks with limited label data, for example, the legal question answering task, could also benefit from our zero-shot approach. And now, before finishing my presentation, I'd like to introduce you to the members of the NeuroMind team. And to conclude, I'd like to thank you all for watching.
Thank you very much, Mr. Guilherme, for your brilliant presentation. It is very nice for us Brazilians to have you here. And now I have one question from the audience. So Mr. Marcelo Lopez from the organization team, he's asking, what are the main difficulties in using fine-tuned models in the legal domain?
I think that the main difficulty is the low availability of label data to fine-tune the models. That's why we are proposing this approach using a zero-shot model.
Perfect. Thank you very much, Mr. Guilherme. Now you have one last minute for a last talk, please.
I simply would like to thank you for the opportunity, and it's a pleasure to participate in this event.
Thank you very much, Mr. Guilherme. It was a pleasure for us. Now, directly from Japan, I'd like to call here to the main stage Mr. Ken Sato, which will have 5 minutes for a demo live presentation of interactive system of arranging issues based on PROLEG and civil litigation. So please, Mr. Ken Sato, the floor is yours.
Can you see the slide?
Yes, we can see your screen perfectly.
I'd like to show you interactive system for arranging issues based on PROLEG in civil litigation. This is joint work with Kazuo Takashi and Tatsuki Kawasaki. Firstly, I would like to give a background and then I give a demonstration. So in Japan, we have the procedure of arranging issues in civil litigation where we clarify which facts are in dispute and what kind of evidence action should be made. And in the beginning of 2020, the Japanese court decided to use online meeting software for arranging issues, but it is very superficial IT technology. So I would like to make it more intelligent. And we have been developed PROLEG-based legal reasoning support system PROLEG since 2009 to simulate reasoning by judges in litigation. In this presentation, we extend PROLEG into an interactive system for arranging issues. So it is necessary to extract the legal facts from various real-life facts to form an appropriate argument in the court. However, it is not clear which of real facts are needed, and PROLEG can choose required facts automatically by reasoning about the rules, which encodes a civil code. So the demonstration is as follows. The plaintiff Alice requested the defendant Bob for the payment of goods according to the purchase contract with Bob. Bob claims that Alice threatened Bob to buy the goods for a counter-argument, but Alice didn't admit the threatening action. So I'll show you now the demonstration. And first, the plaintiff chooses what he would like to do. And here, I want to request money, and then the user chooses which reason why he could request money, and in this case, purchase contract. Then the PROLEG compute the necessary fact, and user plaintiff must put relevant fact here. And this part is changed from Q to O, which is that the plaintiff states it, allege it. And then we can simulate judgment here, and this part becomes O, which means that the plaintiff wins. And then this block diagram is sent to defendant, and then he asked PROLEG to compute counter-argument here. Then we can see that there are two possible counter-arguments, and in this case, defendant choose this counter-argument and put necessary facts here. So these facts are also computed by PROLEG automatically. And we claim this, then apply it. And then we can simulate judgment again with this added fact. And then this becomes crossover X, which means that the defendant wins or and the plaintiff lose. So then it is sent to plaintiff again, and then the PROLEG computes counter argument here. But unfortunately, there is no counter argument here. So only he can do is to deny the fact or making the facts issues, so that it becomes U, and this part is also U. So he denies duress action here. And then we can simulate the judgment again. In this case, this part becomes U undefined unless these issues are solved. So we can arrange the issues using this interactive system. So I conclude my talk by using extension PROLEG. Attorneys can prevent missing claims by using this system for checking, and the layperson could make correct legal claims. As a future work, we would like to develop the system and pursue automatic information extraction from natural language sentences. Thank you very much.
Thank you very much, Mr. Ken Sato, for your brilliant presentation. And now, directly from Canada, I would like to call to the main stage Mr. Ernest Thiessen and Mr. Graham Ross to a live demonstration of a working collaborative e-negotiation system. Please, Dr. Ernest, the floor is yours.
Okay, hi, it's great to be here, and following me is going to be Graham Ross. I'm from Smart Settle, and Graham Ross is working with us as well, also representing ODR training. So I'm going to share my screen now. I've got a short presentation here. Let me see, you should be able to see now the first screen. It says optimizing e-negotiation outcomes with collaboration algorithms. So, we were asked to do a demo of Smart Settle Infinity in 5 minutes. There's no way we could do that. So this 5-minute presentation is just about the algorithms, and but we did produce a video for you. And it's called Infinity Made Simple on YouTube. So when we're done here, you just search for Infinity Made Simple. It's a negotiation between teacher and farmer, and some issues about negotiating pumpkins there. And so in the original distributive negotiation, they were lucky to achieve 50%, but they could do better with those algorithms. So let's see how. If we rearrange the scale, we can depict this problem and change it into an integrative negotiation in multi-dimensional satisfaction space. Now, teacher wants to be at the top left, and the farmer wants to be at the bottom right. When the previous
I'm not seeing the screen. I don't know if it's just me, but
oh,
I'm not.
Oh, you can't see the screen.
Yeah.
Oh no.
Does anybody else can see it? Ah, it's coming on now. Now we can see it.
Now we can see it. Yes. No problem, Dr. Ernest. You can start again if you need. Okay.
Oh, okay. Well, let me see. Let's just try that again.
Okay, we're at the beginning now. Yeah.
Can you see it now?
Yeah. We can see with your notes.
Yes,
you want to play it?
Yes.
Okay. Let's see.
If you play it.
Again.
Okay.
How about now?
Yep.
Is that better?
Perfect.
All right. So it's about optimizing outcomes with collaboration algorithms. And you heard what I said before, that this is about the background theory. So we made a video for you called Infinity Made Simple on YouTube. It's about teacher versus the farmer, and negotiating about pumpkins. There's lots of issues, and they would be lucky to achieve 50%, but we can do better with those algorithms. So, okay, so we're going to rearrange those scales so we can look at the problem in multidimensional satisfaction space. Now, teacher wants to be at the top left, and farmer wants to be at the bottom right. So in the previous scenario is plotted, we can see that it's actually possible to do better. You know, they're short of the efficiency frontier here. And a famous person called John Nash, Nobel laureate John Nash, worked on this quite some time ago, and he said, traditional negotiations end up at the Nash equilibrium. However, with maximized utility product and a dose of collaboration, negotiators can get to an optimal solution. Unaware of Nash's solution, my major advisor at Cornell University gave me a challenge, and I invented maximize the minimum gain. My experiments predicted 16% gains for each party. And the late Harvard professor, Emeritus Howard Rafa, considered then to be a leading expert, published a preference for this algorithm. But unfortunately, further research showed that this method was incomplete. Negotiators are very attached to the baseline and too exhausted to go further. Some years later, visual blind bidding was born. Visual blind bidding virtually eliminates the tedious negotiation dance that characterizes traditional negotiations. A comprehensive process first creates a single negotiating framework. This is like the final agreement, except for blanks representing the unresolved issues. Sophisticated modeling enables parties to represent their preferences so that they can easily determine how much each package is worth, and also define minimum satisfaction. Any area above is called the zone of possible agreement. The neutral site helps parties exchange proposals, and neither of the initial proposals here is acceptable to the other party. But Smart Settle, knowing how each party becomes satisfied, can generate intelligent suggestions. If the parties place secret bids on satisfactory packages, Smart Settle will check if there's an overlap. If there's a small gap, then the automatic deal closer can close it instantly. Fairness enhancing normalization encourages parties to focus on what they want by making sure that no one is able to game the system, while maximize the minimum gain harvests and fairly distributes any remaining hidden value. In the rare case of no agreement in final session, the expert neutral deal closer can guarantee a collaborative outcome. Throughout the process, another algorithm called Reward Early Efforts works to discourage holding back. Increased settlement rates save time and money in all types of negotiations and promote access to justice. 3 decades of R&D have resulted in the 8 algorithms listed here. You can learn more on the Smart Settle website. Search for Infinity Made Simple on YouTube to view the simulation that I talked about. And thank you very much for your attention. It's great to be here, and over to Graham Ross.
Thank you, Eddie. A pleasure to be here, to be invited to present here. Let me give you a working UK lawyer mediator, as I am, perspective of the Smart Settle products, which I have used, particularly Infinity. First of all, just, I suppose, introduce myself. I'm, as I said, a UK lawyer mediator. I'm a board member of the International Council for Online Dispute Resolution. If you've never heard of it, ICAIL.org. If you're interested in online dispute resolution, you really want to be a member. I'm also a board member of Smart Settle Resolutions Incorporated, a member of the Working Party of the UK's Civil Justice Council ODR Working Party, and I've been running for some 13 years the leading training course on ODR. But let me give you this perspective. I really love Infinity. And let me give you 5 reasons. I love it because no settlement is ever reached on the system unless it's been notified as acceptable to both parties. So this is not the machine telling people how to resolve. It's helping people to resolve it. I love how it requires skilled mediators to accurately inform the machine of the preferences of each party. So there's no jobs, no mediators going to be out of work because of this. This is an example, a very good example of that other AI, augmented, not artificial intelligence. It's augmenting the skill of the mediator. Thirdly, I love how the parties can submit proposals to the system anonymously, and the other party doesn't know when it looks as a proposed package to settle if it came from the opponent, from the mediator, or from the machine, because the machine learns so much from what is fed into it that it can identify what is more likely to be acceptable to both parties. In that way, proposals that are made are looked at in a truly objective fashion without any emotion. And you know, when there's a lot of anger and in a dispute between parties, often people will not accept an acceptable offer simply because it came from that other person with whom he is in disagreement. Fourthly, I love how you can use it even outside of mediation, just for a party to model a negotiation strategy before entering into mediation. And fifthly, and finally, I love how it focused the parties' minds from the outset on the final part of it, the resolution, rather than spending all this time arguing over the previous facts that led people into the dispute in the first place. It's extremely positive. Just give you one, finally, a real world example of how all this fits in. Imagine an unfair dismissal. An employer sacks somebody and the employee feels it was done infernally and he has rights to claim compensation. Now, supposing that when this employee took up the employment, the contract said that when he left the employment of the company, he mustn't work, he could not work in the same industry for 2 years. Now, using Infinity, the mediator would want to find out from the employer what their interest in maintaining this bar out really was. Now, imagine the employer said, oh, we're not really bothered about this bar out. This man can't cause us any damage. He wasn't very high up in the in the food chain. Whereas for the employer's point of view, he might tell the mediator using Infinity, trying to assess his preference, that it was really be really important if he could avoid having this bar out. And so in this situation,
Graham, they want us to wind it up.
Sorry?
They want us to wind it up now.
Yeah, so I'm right on the end. So Infinity would say, maybe the employee will take less compensation if he is released from the bar out. And that's how, if that was put openly, it would never be accepted by employee. He would never want it known that they weren't that important. There you are, falling in love hopelessly with Infinity, and I recommend it. Thank you very much.
Thank you very much, Dr. Graham, Dr. Ernest. It was our pleasure to have you here. And this is the end of our panel, our 4th panel of the day. I'd like to thank everyone, our audience. And finally, I'll very quickly share my screen and show you where GatherTown is on our OpenFi platform. We are all going to meet during this 1 hour and a half break there in GatherTown. So I'll just share my screen here and show you how to log in on GatherTown. Can you see my screen correctly, like GatherTown with the home page here? Can you see, Dr. Ernest? Okay. So here in GatherTown, go to the left part of the panel and click here in the star, on the star, where is GatherTown. So here you can join us, okay, inside the platform, and you click there and you have Gather. You only have to prepare yourself here, write your name on it, and launch with your browser, and we will be there for networking space. So you are all invited to join us there. Our sponsors, they have also a place there. I guess you can see my screen, right? I'm using here GatherTown. So I just joined the room, and I'll be in Jus Brasil room here with, for example, Mr. Giuliano is here with me, and there is another room which is Albert Einstein room that you can also have this option to join it. Okay, so you're all invited to join us at GatherTown.
So which room should we go to?
Sorry?
Which room are we supposed to go to now?
Now, yeah, we just finished our transmission and we are finishing the panel. And then if you want to join us for networking space on OpenFi, you have to log in there and go to GatherTown. Okay, so thank you very much for your attention.